Hi, today's FAQ, frequently asked questions, is about California's political laws. So, for those who are not familiar, I put together a series of questions and answers for some of the more common queries that are posed regarding California's political laws found in the California Government Code. So, what created the Political Reform Act, the PRA? The PRA was adopted by the voters on June 4th, 1974 by Proposition 9. Are all PRA filings open to the public? Yes. Every report and statement filed is a public record open for public inspection, as well as reproduction during regular business hours. Now, there are some copying charges, of course, that will apply. What is a behested payment? It means a payment that is made at the behest of a committee, an elected officer, a member of the PUC, or an agent of any of those. Who is a public official? It means every member, officer, employee, or consultant of a state or local government agency. Who is not a public official? The definition excludes a judge or a court commissioner in the judicial branch of state government, as well as a member of the Board of Governors and designated employees of the State Bar of California, also a member of the Judicial Council, a member of the Commission on Judicial Performance, and a federal officer or employee serving in their official federal capacity on a state or local government agency are also not public officials under the PRA. What is a state agency? It means every state office, department, division, bureau, board, and commission, as well as the legislature. What is the role of the FPPC, the Fair Political Practices Commission? The FPPC has primary responsibility for the impartial, effective administration and implementation of the Political Reform Act of 1974. Does the FPPC issue advisory opinions? Yes, they do. Any person may request the FPPC to issue an opinion with respect to that person's duties under the PRA. Also, any person who acts in good faith on an opinion issued to that person by the FPPC is not subject to criminal or civil penalties for acting, provided, of course, that the material facts are as stated in the opinion request. How does the FPPC initiate an investigation? Well, either upon the sworn complaint of any person or on its own initiative, the FPPC must investigate any possible violations of the PRA relating to any agency, official, election, lobbyist, or legislative or administrative action. Does the FPPC have to notify a person about its investigation? It says that the FPPC cannot make a finding of probable cause regarding an alleged violation of the PRA unless at least 21 days prior to the FPPC's consideration of the alleged violation, the person who is alleged to have violated the PRA is notified of that violation by service of process or registered mail and provided with a summary of the evidence, and that person is informed of their right to be present in person and represented by counsel at any official FPPC proceeding. Does the FPPC have to hold a hearing about an alleged violation? The FPPC may hold a hearing to determination if a violation has occurred. Does the FPPC have to accept an administrative law judge's decision? No, but whenever the FPPC rejects the decision of an ALJ, an administrative law judge, then the FPPC is required to state the reasons in writing for rejecting the ALJ's decision. What are the potential bases of liability for a violation of the Political Reform Act? One, violating any provision of the PRA. Two, purposefully or negligently causing any other person to violate any provision of the PRA, or aiding or abetting any other person in violating any provision of the PRA. Is there any alternative to an administrative proceeding under the PRA? The FPPC may establish and administer what's called a political reform education program For persons who violate the PRA, there are some specified limitations that program would be subject to. What powers does the FPPC have in conducting its investigations? The FPPC may subpoena witnesses, compel their attendance and testimony, administer oaths and affirmations, take evidence, require subpoena the production of records and other items that shall be provided to the FPPC. Is the FPPC's decision subject to legal challenge? Yes. An interested person may seek judicial review of any action of the FPPC. Are there limitations on agency officers being involved in license, permit, or entitlement proceedings? Yes. While a proceeding involving a license, permit, or other entitlement for use is pending, and for 12 months following the date that a final decision is rendered in that proceeding, an officer of an agency is prohibited from accepting, soliciting, or directing a contribution of more than $250 from any party or the party's agent or from any other participant or participant's agent where the officer knows or has reason to know that the participant has a financial interest. Are there any exceptions when a public official has to recuse themselves due to a contribution in excess of $250 in a proceeding? Yes, a public officer or public official is not presented or prevented from making or participating in the making of a governmental decision to the extent that the official's participation is legally required for the action or decision to be made. However, note that the fact that an official's vote is needed to break a tie does not make the official's participation legally required. Next, can a legislator be involved in any legislation or actions that would personally benefit the legislator financially? Any member of the legislature cannot make, participate in making, or in any way attempt to use the member's official position to influence a specified governmental decision in which the member knows or has reason to know that the member has a financial interest in the outcome of that decision or action. What are examples of prohibited governmental decisions for legislators who have a financial interest in the decision's outcome? It includes approval, modification, or cancellation of any contract to which either House or a committee of the legislature is a party. It means prohibiting the introduction as a lead author of any legislation that the member knows or has reason to know is non-general legislation. Participating in any committee or floor vote on what the member knows or has reason to know is non-general legislation, and any action or decision when the member received compensation from a lobbyist employer who would benefit from the action or the decision. What are prohibitions involving elected state officers? They are prohibited from making or participating in the making of or using the officer's official position to influence any governmental decision before the agency in which the elected state officer serves, where the officer knows or has reason to know that the officer has a financial interest in the outcome. When does an elected state officer know or have reason to know about a financial interest in an action or decision? Well, either when the action or decision will have a direct and significant financial impact on a lobbyist employer for which that officer has received any income within the preceding 12 months. And in general, you can't have the elected state officer cannot have a direct and significant financial impact by that particular action or decision, as well as if they received any compensation within the preceding 12 months for the purpose of appearing, agreeing to appear, or taking any other official action on behalf of that individual before any local board or agency. When does a public official have a financial interest in a decision? The public official has a financial interest if it's reasonably foreseeable that the decision will have a material financial effect, distinguishable from its effect on the public generally, on that official, a member of the official's immediate family, or on any business entity, real property, or source of income where the public official has a direct or indirect interest. Are there prohibited activities of state agency public officials? Yes. A public official of a state agency is prohibited from being paid to act as an agent or attorney for or otherwise represent any other person by making any formal or informal appearance before or any oral or written communication to the official state agency or any officer or employee if the appearance or communication is for the purpose of influencing a decision on a contract, grant, loan, license, permit, or other entitlement for use. Do elected officials have to file statements of economic interest? Yes. Every person who's elected to a specified office is required within 30 days after assuming that office to file a statement disclosing the person's investments and the person's interest in real property held on the date of assuming office and income received during the 12 months before assuming office. Do appointed officials have to file a statement of economic interest, SCI, otherwise known as a Form 700? Yes, every person who's appointed or nominated for a specified office is required within 30 days after assuming that office to file a statement disclosing the person's investments, as well as their interest in real property held on the date of assuming office and any income received during the 12 months before assuming the office. Does the statement of economic interest have to disclose any business positions held? Yes, which means any business entity in which the filer is a director, officer, partner, trustee, employee, or otherwise holds any position of management. What happens if a person makes a gift totaling $50 or more in a calendar year? That person must disclose to the recipient of the gift both the intermediary or the agent's own full name, street address, and business activity, as well as the full name, street address, and business activity of the actual donor. What is the definition of an honorarium? It generally means a payment, any type of payment that's made in consideration for any speech that's given, an article published, or for attendance at any public or private conference, convention, meeting, social event, meal, or similar gathering. Who is prohibited from accepting any honorarium? An elected state officer, an elected officer of a local government agency, a candidate for office, or certain other specified individuals are prohibited from accepting any honorarium in the state. Is there a gift limitation on an elected state officer or elected officer of a local government agency? Yes. They're generally limited to about $590 per year from any calendar source. What are the rules concerning travel expenses? There are detailed rules regarding travel, including actual transportation and related lodging and subsistence that is reasonably related to a legislative or governmental purpose or to an issue of state, national, or international public policy. And these expenses are generally not prohibited or limited in specified circumstances. Can campaign funds be used for charitable functions? Campaign funds may be used to make donations or loans to bona fide charitable, educational, civic, religious, or similar tax-exempt nonprofit organizations, so long as no substantial part of the proceeds will have a material financial effect on the candidate, the elected officer, the campaign treasurer, or any other individual or an immediate family member of one of those individuals, as well as where the donation or loan bears a reasonable relation to a political, legislative, or governmental purpose. Can campaign funds be used to pay for vehicle expenses? Well, as you might imagine, there are quite a few detailed rules that apply to the purchase of a vehicle, the leasing of a vehicle, and the operating costs of the vehicle. Can campaign funds be used for leasing real property? No. They can't be used for payment or reimbursement for the lease of real property or for the purchase, lease, or refurbishment of any home type appliances or equipment. Can campaign funds be used for home security systems? They can be used for the cost of installing and monitoring an electronic security system at home or office or both, as long as the candidate or the officer has received threats to the candidate's personal safety and that those have been reported to and verified by an appropriate law enforcement agency. Can campaign funds be used to pay for cybersecurity devices? Yes, they can, for the cost of installing and monitoring hardware, software, or other services for cybersecurity of electronic devices. Can campaign funds be used to compensate an elected official? No, they cannot be used to compensate a candidate or an elected officer for the performance of political, legislative, or governmental activities. Again, they can reimburse for out-of-pocket expenses as long as those are incurred for political, legislative, or governmental purposes. What is the liability for a person who violates the honorarium or gift laws under the PRA? Any person who makes or receives an honorarium, gift, or expenditure in violation of the PRA is liable in a civil action brought by the FPPC in an amount up to 3 times the amount of the unlawful honorarium, gift, or expenditure. What does the Political Reform Act require the FPPC to do? It requires the FPPC to regulate campaign finance laws, conflicts of interest for local and state public officials, bolster lobbyist registration and reporting, regulate political mass mailings, as well as the gift laws. Who makes appointments to the 5 FPPC commissioners? The governor has 2 appointees, the Attorney General, the Secretary of State, and the Controller each appoint 1 member of the FPPC, therefore for a total of 5 members. Can the FPPC commissioners be removed? Very specifically, the members of the FPPC may be removed by the governor with concurrence of the Senate for substantial neglect of duty, gross misconduct in office, inability to discharge the powers and duties of office, or for a violation of specified sections of law applicable to them. And those are my FAQs on California political laws.